over key points from Module 5 on protection, we've learnt that a person who can get adequate protection from the authorities or in his or her home country is basically not a refugee. Now, the definition of protection has been a controversial one, and if we turn to the Qualification Directive as a shortcut, we know that protection is generally provided where the authorities take reasonable steps to prevent the persecution or suffering of serious harm, for example by operating an effective legal system for the detection, prosecution and punishment of acts of persecution, and the asylum seeker actually has access to that protection as well. Now, in the UK, that was already the law before the commencement of the Qualification Directive. It was often referred to as sufficiency of protection and is derived from a case called Horvath. Now, this issue of sufficiency of protection and a system of general protection doesn't really arise in cases of state persecution, because where the state is the persecutor, then obviously the state can't also be the protector. So it only really arises in cases of non-state persecution, where the asylum authorities in the UK or the asylum state will say, well, why didn't you or why couldn't you approach the authorities of your own country for protection rather than seeking asylum abroad? And it can be very hard for citizens of developed democracies to make out a successful claim for asylum where the persecutors are non-state actors of some sort.